Federal government employees affected by the fork-in-the-road buyout offer have sued to stop the offer. Let's take a look. In the United States District Court for the District of Massachusetts, the American Federation of Government Employees, AFL-CIO, and the National Association of Government Employees have sued Charles Ezell in his official capacity as the acting director of the Office of Personnel Management. They argue that the fork directive, as currently drafted, is arbitrary, capricious, and not in accordance with law, in violation of the Administrative Procedure Act. They ask the court to vacate the fork directive and remand to the Office of Personnel Management to provide a reasoned basis, as required by the APA for the directive, and extend the purported deadline for said directive accordingly, to preliminary and permanently enjoin officials from implementing or otherwise giving effect to the deadline on February 6th until such time as defendants can provide adequate legal justification for the directive, and adequate legal assurance of its terms. That the court order the officials to submit a corrective communication to all government workers advising them that the directive is suspended and the deadline held in abeyance for a period of time not less than 60 days, and award cost attorney's fees and other disbursements for the action. And they've made a motion for a temporary restraining order, which is a expedited order that's good for 2 weeks that judges usually put in place in order to maintain the status quo while they consider a more permanent but not permanent preliminary injunction during the litigation. Then we'll have a permanent injunction afterwards if the judge deems it appropriate. So they've made said motion for a temporary restraining order and asked for a hearing before or on February 6th in order to beat the fork directive deadline. In support of their TRO motion, they say, "The continued success of government is based in large part on the institutional memory of its career civil servants who are committed to the missions of their agencies and the prospect of working for the American people. These civil servants are professionals and subject matter experts, many of whom have worked diligently and impartially through successive administrations of both major parties to implement changing priorities. If these employees leave or are forced out en masse and without regard for their role or function, the country will suffer a dangerous 1-2 punch. First, the government will lose expertise in the complex fields and programs that Congress has, by statute, directed the executive to faithfully implement. And second, when vacant positions become politicized, as this administration seeks to do, partisanship will be elevated to the detriment of agency missions and the American people." On January 28th, Defendant Office of Personnel Management, OPM, surprised nearly all federal employees with an email entitled "Fork in the Road," announcing what OPM called a deferred resignation program, offering employees the ability to resign now and purportedly retain all pay and benefits until September 30th, 2025. Federal employees were only given 10 days, until tomorrow, February 6th, to decide whether to take the offer or face the prospect of losing their employment without pay through the downsizing and reductions in force also threatened by the directive. The directive is unlawful. OPM offers no basis for its authority to adopt this program, and OPM purports to guarantee funds that Congress has not appropriated, in clear violation of the Anti-Deficiency Act. The directive is also stunningly arbitrary. OPM has given federal workers just days to make critical decisions about their futures and livelihood, even as OPM has repeatedly changed the contours of the program. OPM has recklessly ignored the directive's significant adverse consequences on the continuing functioning of government, encouraging the potential departure of broad swaths of employees without regard to their agency, job duties, or institutional memory. The directive also skips past the rules and processes of governance, including long-standing rules governing federal employees, the availability of alternative models of reasoned government downsizing, and the sheer chaos seeded by importing Elon Musk's questionable private sector business model to the federal government. At the same time, OPM's directive is pretext for removing and replacing government workers on an ideological basis. Plaintiffs, who collectively represent over 800,000 federal workers, have a direct interest in counseling their members to allow them to make informed decisions about their employment, and plaintiffs' ability to do so is compromised by OPM's irrational and illegal offer, made on such a compressed and arbitrary timetable. In the absence of a TRO, plaintiffs will be irreparably harmed by long-lasting impacts of the rushed and ill-informed choice the fork directive has foisted upon their members. As plaintiffs expend resources that cannot be recovered trying to help their members make sense of OPM's ever-shifting ultimatum, they are thwarted in their counseling of members for lack of consistent information, and they stand to lose members in significant numbers. Accordingly, plaintiffs seek a temporary restraining order staying the February 6 deadline to accept the fork, while plaintiffs seek further relief ensuring OPM completes the required consideration of the directive's legal basis, justification, and funding. Real quick, what are they talking about? Again, the powers of the federal government are limited. They are enumerated in the Constitution. There are approximately 18 enumerated powers, and whatever powers are not given to the federal government does not have that power. So, in your structure of federal government, you have the legislative branch that makes the laws, the executive branch that carries out the laws, and the judicial branch which interprets any disputes or vague language, etc., interprets the laws and adjudicates the laws. When Congress wants to delegate some of its authority to an agency to do a job like manage personnel, it has to do so by passing a law. That law here is the Administrative Procedure Act, which allows for administrative agencies to carry out the rules and laws made by Congress and take some of the burden off of the executive branch. So, you can't just do whatever you want with any government employee ever. You need to follow some basic rules of governmental power. The executive branch, the president, cannot override laws made by Congress or interpretations of law made by the Supreme Court. So here the plaintiffs are saying that these executive orders and the action that Elon Musk is taking with Doge or Doge or whatever the heck it is are not legal because they were not authorized by Congress, and nor is the fork in the road directive. That doesn't mean Congress couldn't authorize it at some point, but it does mean that there is currently no authorization for anything more than what is already authorized, and what's authorized is less than what is being offered. So the offer, the fork in the road offer, goes beyond the law. It is ultra vires. It is outside of its power. It is doing more than it is allowed to do. And that's a huge risk because we just saw in the previous video that if the government's wrong about that, that's your problem, not the government's problem. On January 28th, OPM sent an email directly to nearly all federal employees with the subject line, fork in the road. The email purported to offer a blanket program of deferred resignation to millions of civil servants. OPM directed employees to respond to the email with a single word, resign, within little more than a week, if they wish to receive pay through September 30th. The directive suggested that failure to take this offer could result in the loss of employment without pay. OPM threatened that the majority of federal agencies are likely to be downsized, and that career civil servants will likely lose their employment protections in large numbers through the reclassification to at-will status. This is a serious misunderstanding of law on the defendant's part. At will does not mean you can be fired for any reason without consequences. At-will employment means you can be fired at any time. It does mean that you can be fired without cause. It does not mean that you can be fired without cause, without consequences to the employer. So even if they are allowed to lay off all of the government employees, they still need to do so with cause if they expect to get away without paying benefits and wrongful termination packages, severance packages, etc. So this threat to reclassify them to at will doesn't really mean anything. Yeah, they can reclassify them to at will, I guess, through an act of Congress. And upon doing that, they can be fired, but they can't be fired without cause, without consequences. For those who declined to resign, OPM made clear that it offered no assurance regarding the certainty of your position. At the same time, the administration has made clear that it seeks to quickly fill newly open positions with individuals who are politically aligned with the current administration. Some agencies are meant to be independent and are not meant to be staffed by the people who only serve at the pleasure of the president. The only people who serve, quote-unquote, at the pleasure of the president and can be hired and fired at will are the inner circle, the highest tier of the executive branch. Those who work in the agencies, for the most part, with some exceptions, some agency heads can be fired, that kind of thing, not the employees of the federal government, not the 800,000 employees of the federal government. They can't generally be fired at the president's will, no. OPM's shifting guidance and implementation has offered conflicting information about employees' rights and obligations under the directive, sowing mass confusion across the government. As recently as February 4th, just 2 days before the acceptance deadline, OPM sent the directive to individuals it had deemed ineligible to participate. OPM has continued to revise its position on whether employees would be required to work if they accepted the deferred resignation offer, initially requiring employees to work but be exempted from all applicable in-person work requirements, then stating that only in unspecified rare cases would employees be required to work, and finally, in an apparent attempt to sweeten the deal, flatly stated that no work was required. OPM even encouraged workers to seek other employment during the deferred resignation period, stating that employees were absolutely allowed to get a second job. Wait, wasn't that one of the derogatory and, I guess, false things that they said all the employees need to return to office because they're getting a second job or something? This is probably not true. I'm not saying no one has ever done it, but the vast majority of the 800,000 federal employees are not doing a second job while they're doing their federal job. And if anybody was, that's a for-cause terminable offense. But here they are saying, oh, you should get a second job while we're still paying you your government salary. Likewise, OPM's guidance on employees' entitlement to pay has also shifted. In the directive and initial guidance, they originally said without equivocation that yes, employees will really receive full pay and benefits through September 30th. And of course, my position is that when the continuing resolution currently funding the federal government runs out, if these benefits are over a $25,000 limit set by, I think it's Vera, then none of these people are going to get paid the full amount. And we saw from the Richmond case, OPM versus Richmond, that the government can tell you the wrong thing and you're up a creek without a paddle. If they're wrong and you depended on it, you don't have a claim against the government. Unless something new happens and someone creates that claim, like Congress or the Supreme Court or something, current law and current continuing resolution and current congressional action or inaction supports that there's no backup for this. There's nothing that makes the fork in the road directive a real deal. OPM later explained that while a lapse in funding may occur, employees would unequivocally be entitled to back pay in the case of a lapse in appropriations. Then OPM issued another piece of guidance, this time saying that promises of full pay and benefits are binding, but also stating that were the government to backtrack on its commitments, an employee would be entitled to request a rescission of their resignation. Particularly in light of the dramatically compressed timeline, guidance continues to shift in a way that obscures the true nature of the directive from plaintiffs, federal employees, and the public. OPM did not look to historic predicates for government downsizing, instead adopting a questionable private sector model championed by Elon Musk. In the mid-90s, President Clinton sought to reduce government staffing and increase efficiency. After an extensive information-gathering process, legislative approval by Congress, and a targeted and orderly approach to buyouts, the Clinton administration reduced more than 100,000 federal government positions. In contrast, the fork directive appears to incorporate a wholesale staff reduction approach of the same model conducted by Elon Musk shortly after taking over Twitter, now X. OPM has offered no explanation as to the legal basis or authority for the directive, or any appropriation to fund it, as in any congressional approval. Indeed, the directive purports to obligate agencies across the federal government to guarantee pay and benefits until September 30th, 2025, for employees who accept this offer by February 6th. But Congress has not appropriated funds for the executive branch beyond March 14th. Plaintiffs who are routinely called upon to advise their federal employee members are unable to render dependable advice, etc. So, the standard for a temporary restraining order. The plaintiff must show likelihood of success on the merits. They must show irreparable harm. They must show a balancing of the equities, as in the fairness principles, and they must show that such relief is in the public interest. That's your standard. That's what we have to meet. The plaintiffs argue that they are entitled to a temporary restraining order. First, they are highly likely to prevail on the merits given the myriad ways in which OPM's action is arbitrary and capricious and in clear violation of the Anti-Deficiency Act. So arbitrary and capricious violates the Administrative Procedure Act and the binding of the government to a promise that isn't authorized by Congress. That's the Anti-Deficiency Act. Second, plaintiffs will be irreparably injured absent injunctive relief because they have had to and continue to divert substantial resources that cannot be recovered to counsel employees about the directive. They are hamstrung in their ability to deliver their core service of counseling to their members who look to plaintiffs for guidance, and they risk losing members who resign. Third, the balance of equities and public interest favor relief, as the public has no interest in an arbitrary and capricious program that obligates federal resources without congressional appropriation. It fails to take account of its impacts, and it's irrational, even judged by its own logic. Under the APA, a reviewing court shall hold unlawful and set aside agency action, findings, and conclusions that are arbitrary and capricious, an abuse of discretion, or otherwise not in accordance with the law, or in excess of statutory jurisdiction, authority, or limitations. Here the directive fails this standard in multiple respects, and plaintiff can more than satisfy the requirement of showing a likelihood of success on the merits. The fork directive is arbitrary and capricious. An agency action is arbitrary and capricious if the agency lacks a rational basis, which includes instances where the agency relied on improper factors, failed to consider pertinent aspects of the problem, offered a rationale contradicting the evidence before it, or reached a conclusion so implausible that it cannot be attributed to a difference of opinion or the application of agency expertise. It is axiomatic that the APA requires an agency to explain its basis for a decision. The agency's explanation, then, must include a rational connection between the facts found and the choice made. OPM's rash solicitation to nearly all federal workers across hundreds of federal agencies is arbitrary and capricious in numerous respects. First, OPM has failed to consider obvious and vital considerations attendant to the directive. Most notably, perhaps not surprising for a program that was established mere days after the new administration took office, the directive fails to address critical concerns of continuity and effective governmental operations that will predictably flow from the directive. OPM appears to have conducted no analysis on the necessity of the particular positions or expertise, the optimal number of resignations, which agencies were likely to experience high levels of resignations, or where staffing was already woefully insufficient such that resignations would be incontrovertibly harmful to government operations. Nor did OPM consider how hundreds of agencies and their components across the government would ensure continuity of expertise and operations given the sudden administrative leave of some untold number of federal workers. The directive creates no mechanism to ensure critical continuity of services or expertise. The offer largely blankets the entire federal workforce, regardless of job title and expertise. OPM's own statements in the directive acknowledge that there is not a rational connection between the facts found and the choice made to solicit resignations from nearly every federal employee. OPM writes that some unidentified federal agencies require larger workforces to function, stating that a few unspecified agencies are likely to see increases in the size of their workforce. But the directive is offered in blanket fashion to millions of employees without targeting or analysis. This glaring failure to consider federal agency needs for crucial operations, retention of expertise, and continuity of services cannot be attributed to a difference of opinion, and instead reflects that OPM failed to consider pertinent aspects of the purported problem it sought to address with the fork directive. Second, OPM has repeatedly offered conflicting and shifting information about the directive and employees' rights and obligations if they accept the offer, in contravention of reasoned decision-making. In addition to sending the directive to employees that the government ultimately deemed ineligible, OPM has repeatedly changed the contours of the directive. Employees were given conflicting information about whether they would be required to work if they accepted the offer, whether they would really receive full pay, and what would happen if the government were to backtrack. Particularly in light of the extremely compressed timeline, OPM's continual changing of the contours of the program reflects the opposite of reasoned decision-making. Third, OPM's directive is inconsistent with other federal requirements. The directive fails to adequately explain how it is consistent with long-standing ethics rules that place agency-specific restrictions on employees' ability to obtain outside employment. OPM has explained that employees may absolutely obtain additional employment while on administrative leave, but this bald assertion contradicts federal ethics regulations that provide that federal employees who seek outside employment must comply with numerous conditions, including agency-specific requirements. Those regulations further provide that agencies may impose a prior approval requirement before individuals can accept outside employment. Some agencies have codified their requirement for prior approval by regulation, and these policies could hardly be expected to change uniformly in the accelerated time frame created by the fork directive. Neither does the directive grapple with other restrictions for federal employees, including statutory restrictions on receiving dual pay from federal funds. Fourth, the directive ignores prior models of reasoned and effective government downsizing to adopt wholesale a chaotic private sector model without considering its applicability. The federal government has effectively downsized in the past, but has done so only following a careful gathering of information and targeted offers designed to ensure continuity and effective government operations. Congressional approval of funds is included, and reasonable timelines for workers and governments alike. In contrast, and without any indication that the administration considered this history or evidence of effectiveness, OPM has appeared to have adopted wholesale, without testing or analysis, Elon Musk's chaotic approach from Twitter, now X. But that approach was widely regarded as seeding chaos. X is now worth 72% less than the $44 billion he paid for it as of January 30th, 2025. OPM did not even attempt to explain its result in diverging from a well-established recent precedent for achieving its aims, much less provide a reasoned explanation for its decision to create a short-fuse, blanket resignation program without limits or targeting. Fifth, the fork directive sets a deadline of just more than a week for employees to make critical decisions about their lives. This is an arbitrary date defendants selected to put maximum pressure on the federal workforce. Finally, the directive appears to be a pretext for the administration's desire to rapidly remove career civil servants and replace them with individuals ideologically aligned with the administration. The directive concedes that some agencies require more, not less, staffing, and the administration is simultaneously seeking to speed up and politicize the federal hiring process. As Vice President Vance has stated, President Trump should fire every single mid-level bureaucrat, every civil servant in the administrative state, replace them with our people. This, not efficient functioning of government, is the goal. In sum, Congress requires that agency action must be logical and rational. Programs like the fork directive must be the product of a process of reasoned decision-making. But the directive, an unprecedented adoption of a chaotic private sector program to the near entirety of the federal workforce, is anything but that. The Appropriations Clause of the Constitution commands that no money shall be drawn from the Treasury but in consequence of appropriations made by law. In 1870, Congress enacted the Anti-Deficiency Act to address the increasingly common problem of the executive branch obligating funds in advance of appropriations, which pressured Congress to then appropriate those funds so that creditors would be paid. The Anti-Deficiency Act bars a federal employee or agency from entering into a contract or future payment of money in advance of or in excess of an existing appropriation. So in other words, you can't bind the federal government to a debt or a contract or whatever unless it's got the backing of Congress through a law or other appropriate legislation or rulemaking. Congress is the point, not president. To induce resignations, OPM has not only promised that they will be paid through March 14th, the time period in which the government has existing appropriations, but through September 30th. This is contrary to the Anti-Deficiency Act, which prohibits government employees from obligating expenditures prior to an appropriation. And OPM's later effort to clean things up, stating that a lapse may occur but employees would receive back pay, cannot cure its anti-deficiency violation. First, the untimely addition of sentences does not change that OPM promises that pay and benefits will be honored past the March 14th appropriations deadline, which is contrary to the Act. Whether furloughed employees may receive back pay by statute after an appropriation does not change the bar on obligating expenditures before an appropriation. In other words, you have to wait for Congress to act. And OPM's directive and accompanying FAQs continue to commit the government unequivocally to pay the employees who resign. Second, there is no guarantee that Congress will fund past March 14th the salaries of those who accept the fork directive's offer. Indeed, the current administration and Congress are calling into serious doubt the continued near-term existence of some government agencies that employ the workers subject to the fork directive. It is not at all certain that Congress will appropriate taxpayer funds to pay large numbers of employees for no services, or whether Congress would place restrictions on such funds. Congress enacted a statute in 2016 intended to cabin the use of administrative leave, and OPM itself recently issued implementing regulations under that statute, reinforcing that view with the position that administrative leave is appropriately used for brief or short periods of time, usually for not more than one workday. Here they're asking for, I think, over 200 days. We'll skip over jurisdiction. On to irreparable harm. Plaintiffs will suffer irreparable harm without a stay of OPM's February 6th deadline. The directive is impeding their ability to fulfill their missions, including through significant expenditures of resources, reputational harms that cannot be remedied, losses of members that cannot be regained, each of which constitutes irreparable injury sufficient for the requested relief. This boils down to the plaintiffs advising their employees, their unionized employees, and having to pay for that. The employees have to advise employees, so the union has to have employees that can advise the employees of the OPM or other federal government workers. And so they could lose members in the form of members resigning from their jobs and therefore not being a member of the union. In my opinion, this is very clearly irreparable harm, and the question is whether or not the previous section wins or loses. The irreparable harm probably isn't that big of a contest. The balance of equities and public interest, this is the fairness and the public interest factors. These are two separate factors, but they often are evaluated together. Where there is a likelihood of success on the merits, preliminary relief is usually beneficial to the public interest. Basically, they argue that the harm on the president/Musk side of the ledger of the calculation is slight. They issued a rash, quickly drafted directive to millions of employees within days of the administration's assumption of office and planned for it to be fully executed hardly more than a week later, by February 6th. OPM's interests will not be significantly harmed by being required to issue a rational and legally authorized alternative version of its directive, or by a short stay while the merits are considered. And that's pretty much the end of the temporary restraining order. So these are interesting times that we're living in. We would call this a constitutional crisis. The structure of American government, the Federated Union of Member States, is going through a contest right now, is going through a challenge. You could probably call it the Second American Civil War. It might not be that violent yet, but it is certainly violent against the legal principles that have stood for hundreds of years. Our country is only hundreds of years old. That's the best we can do. Our country's laws are based on England's laws. That's hundreds, if that not thousands of years old. But America is still a relatively young country in the great scheme of things. I can tell from the YouTube comments and other social media comments that I see that many people do not have any understanding whatsoever of how the federal government is structured, and they believe that the president is a king. And I'm here to tell you, I'll tell you this in another longer video, but the president is more like the chairman of your town council. That's it. Your president should be running the country, your president of the United States should be running the country the way a healthy and appropriate town council chairman is in charge of making your town a nice place to live and making sure everybody gets their garbage picked up on time and is ready for floods or fires or hurricanes or earthquakes, that the people get the health care and education that they need, and that we all are able to live in harmony and thrive together as best as we possibly can. That's what you want your local town council chairman to do, not burn down the town so he can remake himself in the ashes. I'll be covering the legality of the order itself further in another short video, but I wanted to bring this to you as it dropped today. There's probably going to be a hearing either today or tomorrow, and if I can attend that, I'll bring you some of that as well. Let me know what you think in the comments below. Stay vigilant, keep safe, and I'll be here in the videos. Love you all.